the SEBI as a regulator is proactive. They are bringing out various amendment, new laws, and asking the stakeholders for their comments as a consultative paper. So they can give their suggestion, they can react, they can suggest some changes, and then they can finalize. But this is the first time that we are interacting in place of asking only comments, and in the interaction we are giving this options to all stakeholders to participate in the lawmaking exercise. They can read this, give their suggestion, give their viewpoint, raise your concern, so the regulator can have a holistic view and then finalize the changes in regulation. Why the regulator is changing its regulation, law, guidance? There are few factors. One is it is sufficient time has lapsed and the changes are required because of various economic scenario has changed. Some value addition which they have learned from their experience, they want to do it. Some manipulative activities which people were following, taking advantage of the loopholes of the law, they have to stop and they have to tighten this. And sometimes the changes in other laws are taking place, so they want to modify this. Here we have a golden opportunity to suggest our suggestions and understand what are the viewpoints of regulator when they have bringing out these changes. We can learn by this type of program what is their logic, what is the genesis, what are their experience, and then they can give their views also. So today, friends, we have invited Mr. Achal Singh, who is General Manager and one of the pillar who is working this law. Mr. Achal Singh is a and working as General Manager in Corporate Restructuring Division of SEBI. The division primarily deals with policy as well as operational aspects for takeover, buyback, delisting, and employee share-based benefit regulation. That's called ESOP. Mr. Singh has been working in SEBI since 1997 and has regulatory experience in issuing issues relating to FPI, registration of intermediaries, inspection, investigation, enforcement, investor grievances redressal, and spread of financial literacy. He also handled SEBI office in New Delhi, Ahmedabad, and Indore. Mr. Singh has worked in investor grievances redressal division, so he knows that what are the investors' problem in this. And then second is that he has worked in the inspection and investigation division also, so he knows what types of problems the people are doing. Friends, today's program we have divided into various parts, and this is a different type of program, so we have to bring out some innovation. Now, after my remark, Mr. Manoj Kumar, who is a partner and head M&A transaction and insolvency corporate professional, he will discuss genesis and need for delisting. Because Manoj looks after the takeover and he has a rich experience in takeover law. He has done more than 50 takeover offers. So he knows the problems of takeover. So he can suggest us that what is the genesis of delisting, because sometimes we are an investor, we can apply, we can get delisted our shares. But as an academician, as an issue, as an economist, this issue is always that why companies are going for delisting. Is it only compliance or some other reason? And what is the logic that MNCs are delisting? So Manoj will discuss about this and what are the delisting issues he will discuss. Then I will request Mr. Achal Singh, who will discuss about the background and overview of the consultative paper. He will give the macro view on this. And after that, Anjali will start discussion on regulation wise, which as SEBI has proposed, by explaining the existing regulation and the amendment proposed. And Mr. Singh will elaborate on each point given the rational and objective. After that, Anuj Rastogi, who is in the capital market division, he will come out certain points which are not covered in the regulation in the proposed amendment, and certain things which he has prepared. He will discuss that what is left out and what other points can come. And after that, if something is remained, we will take up in the question answer session. My request to all participants that you please send your questions to us so we can ask during the discussion and during the deliberation. Friends, we have taken out the delisting regulation. Delisting guideline came in 2003 first time. And in 2009, this delisting guideline became the regulation. In 2015, 18, 19, 20, various amendments came into delisting regulation. If we compare up to 2015 to 2020, there are 30 delisting. Out of this 30 delisting, 12 delisting has taken place on floor price. 11 delisting has taken place on premium, the floor price suggested by the promoter, which has investor through RBB process has asked more. They thought that this is not the correct price, so they have given this, which is a very unique system of India, the reverse book building process, where the premium was 106% to 1.68%. That 11 issues were delisted. 4 issues rejected by the promoters because they found that rates are not what they think that this is the correct price, and 1 issue is not reached to up to 90%, so that why it's failed. 1 is issue which is takeover plus delisting, that is another aspect, and 1 takeover is not successful because of the regulatory aspect. So these are the some delisting related points which are part of this. Now I will request Manoj to tell us that why companies are going for delisting and what is the reason that MNC are going for delisting, and any other point which you think. Over to Manoj.
Thank you very much. Thank you, Achal sir, and for giving us time and this participating in this deliberation. I think we will be able to find certain issues which may be left out or which need public interest to be taken care of while redrafting of the delisting regulations. So we are talking about why delisting. Basically, we have to understand why a company goes for a listing. First, we need to understand that, and that is the background based on which certain decisions with respect to delisting may be taken. So listing happens generally by the primary issue, that is IPO, and IPO helps to raise fund for the company for its growth. Sometimes it is for the exit of the investors as per the mandate or as per their requirement. Sometimes promoters of the company may also want to have liquidate their stake in the company. So that is offer for sale as part of the IPO. And that is the primary way of getting a company listed. So listing gives several benefits. That's why a company goes for listing on in a capital market. It helps to, it opens several new avenues to raise capital, like QIB placement, qualified institutional placement, private placement of the certain class of investors are interested only in the listed companies. So that is that door gets open. Then rights issue is also there, in which a large number of public may participate in the investment for the growth of the company. So this is the one of the way. Another thing is IPO and listing also brings much more credibility to the organization. It helps to brand the company as a listed entity which has transparency, which has better corporate governance. So it also helps in raising debt funds and other its business becomes more branded, more better in public eyes. So that is one of the criteria. Then value proposition, value unlocking is also very important. Whenever a company is listed, its price shares are traded on the stock exchange, so market value of the business is established. It helps sometimes to use the shares of the listed company for the swap of share, for acquisitions, mergers, and that helps in use of the shares of the company, and that is one of the benefits of a company being a listed company. Now, so this gives various benefits. Then why company try to get delisted? The general sense is when the promoters or the acquirer of a company feels that the market is not giving the correct value or correct picture of the company in the public eyes, then it becomes non-viable to keep the company listed. So that is one of the primary reason why a company get delisted. Listing also requires various kinds of extra compliances. Governance issues are there. Transparency requirements are also there. So if the cost of compliance becomes more than the benefits of listing, then it becomes better to keep the company delisted. Similarly, the size is very small. It is not carrying much business. So in that scenario, obviously valuation may not be the correct in the capital market. There may be certain hidden assets which are not liquidated, which are not put to business. So in all such cases, the valuation of the company would not be correct in the eyes of the market. In all such cases, it is better to keep the company closely held and not in public eyes. So that can be one of the reasons. Then there may be certain situations where there is a global restructuring, bigger kind of structure worldwide, and in which overall parameters, the listed entity may not be a right component. So in such cases, sometimes it is required to get the company delisted. So all these are the things. We see that in many of the cases, and especially the takeover regulation was changed and the new regulation 5A was introduced, where acquirers were allowed to give a joint offer, first delisting offer combined with the takeover offer. Earlier only the promoters were allowed to get the company delisted, but in 2015 new regulation was inserted in takeover, which allowed a new persons who is coming into the company may keep the company after takeover as a closely held company. So basic background was that many of the acquirers were not interested to keep the company listed. We have seen in many of the MNC companies which are getting globally taken over by some another group. They do not like to company to be listed in global scenario. Their size or component of Indian company is very small, and if the company is a listed company, then its market price would be taken as a mark-to-market basis, the investment value of the company, which may not be the right. If the valuation in Indian market is not getting reflected fully, then they have to make impairment in their investment. So that may not suit them. So that becomes very important aspect for them to try to keep the company as a delisted company. Then in some cases, I think we also found that the minimum public holding norm, which is minimum 25% investment should be with the public at large. The promoters or acquirer may not be interested to keep that much dilution in their control or in their sharing of that much wealth of the company. So these are the basic primary reasons for which companies get delisted and try to get delisted. But some delisting offers become successful. Some may not be. So these are the primary reason we have found based on the experience, based on the past record, and that obviously what is the broader scenario. So I think that is the primary thing. some other aspects are also there, like regulatory delisting, compulsory delisting. Then sometimes it is required that listed companies should be merged and with some another company which is not a listed company. So in that case, delisting may be a viable option. So I think broadly these are the things.
Thank you very much for giving overview on this. Now we can understand that when a company is listed, and the delisting is also required, because in Indian ethos we know when you have come तो आपको जाना भी पड़ेगा. So, and it is, India was not good in ease of doing business, because there was a complaint of the international market that in India opening is easy but closing is impossible. So that's why when the insolvency law has come, or one of the delisting issue were there, we have seen in the FERA regime, when the companies were compulsorily listed in the stock in Indian market. So many things has taken place. Now the liberalization has given this opportunity also, that I should be governed by the rule of the market, not by the only law point. So this is the reason which has taken place. So delisting is essential part for the system. Only thing is, the rules of the game should be very clear. The people should not play with the market, with the investor, and the SEBI's role is to protect the investor, because when the delisting is taking place, the most important thing which SEBI is looking after the interest of small investor, because they don't know how to do it. That's why these laws they are making. So now under this same thing, I am now inviting Achal Singh sir for giving the background and overview of this consultative paper, and what is the thought process that SEBI has come out with this, and then we can take up one by one each point. Over to you, sir.
Thank you, Pavanji, and I appreciate the steps which you have taken by having a series of webinar, especially during this COVID time, wherein knowledge sharing is done. And kudos to your entire team for coming out with these webinars. Now, as far as this delisting consultation paper which we have issued, before giving my overview on the delisting consultation paper, let me also tell you about the basic framework of SEBI for delisting. As you have rightly said, interest of smaller investor is key in the mind of SEBI. And you may be aware that the key mandates of SEBI, 3 mandates of SEBI is to protect the interest of the investors in securities, to promote the development and regulate the securities market. The Parliament, while enacting the SEBI Act, has kept the interest of investors in security as the highest pedestal. So SEBI, while framing the law and coming out with the regulation, always keep this in the mind. And the framework for delisting of equity share is also formulated with the necessary safeguard for the protection of investors. Though SEBI also strives to ease the listing and delisting of equity shares by companies in India. Over past few years, to start with, the first time the government of India in 1979 came out with one circular wherein they permitted the delisting of the shares by the company. Then in 1998, SEBI came out with the framework for voluntary and compulsory delisting. Then subsequently, SEBI came out with delisting guidelines, wherein concept of reverse book building was first time introduced, and the prices were fixed accordingly. In 2004, government also came out with a framework wherein necessary amendment was carried out in SCRA Act and allowed the delisting of equity shares. And also in 2014, subsequently government made necessary amendment in the SEBI securities contract rules 1957. so by virtue of this, various conditions were prescribed for the delisting of securities for compulsory as well as delisting of voluntary delisting. SEBI also then subsequently strengthened the framework and in 2009 came out with delisting delisting regulations, and also the said regulations were strengthened from time to time. The last amendment to the said regulatory framework was done in 2018 when the concept of counter offer was introduced. Further, the provision was also made in SEBI SAST takeover regulations, wherein the acquirer can make a delisting offer through takeover route by complying with the delisting regulation. So SEBI has been strengthening the delisting framework over a period of time. As far as the past few delisting offers which has been made, so I have some data from 2017 onwards, April 2017 onwards. So there were 26 voluntary delisting offers from all the stock exchange, except there are those which are NCLT by virtue of NCLT order, because they need not comply with the NCLT, wherein NCLT order is there, need not comply with the conditions. So wherein these completed offers were successful in 21 cases. So out of 21 cases, the offers were successful. And out of those which were successful, 8 were in respect of small companies. Small companies are those wherein the paid up capital is less than 10 crores or net worth having less than 25 crores. So they need not follow the RBB mechanism. So out of those balanced companies, we found that in 9 companies, the delisting were done at the floor price. So broadly, there are a large number of companies wherein the delisting happened at the floor price. As far as the delisting through takeover routes, only 4 offers were done, out of which 2 were successful and 2 were not successful. Beside that, there were also large number of compulsory delisting by stock exchange. Bombay Stock Exchange has done during last 3 years 822 companies compulsory delisting, and similarly NSE has done 134 companies compulsory delisting. So these delistings were wherein non-compliant companies were broadly non-compliant of the law, and the law permits the stock exchange to delist such companies. Now coming to the proposed amendment which are there, which has been circulated by way of consultation paper, during last 2 years, because the last amendment was in 2018 and subsequent to this, we have experience as far as the various delisting offers, including few recent delisting offers. They were wherein subsequent to which large number of representations were also received by SEBI, and stakeholders have given their suggestions and submissions. So a need was felt that the regulation need to be looked afresh in a way that to further streamline and strengthen the delisting the process. So after comprehensive review, we are proposing 23 regulatory changes by way of these consultation paper. And the key objective is to rationalize the existing timelines, because in many cases we found that timelines were not clearly specified. So as to complete the delisting in time-bound manner. So the proposed changes shall reduce the timelines from around 1 year to around 3 months from special resolution. So the time period has been curtailed so as to ensure and facilitate the delisting from the point of view of shareholders as well as from point of view of the company, that the process ends as early as possible. Similarly, disclosure requirement has also been enhanced in a way that information asymmetry is done away with, and whatever information which is there with the company should be made available to all shareholders so that they are able to take informed decisions. Then similarly, we have refined the process, improved governance of the companies by ensuring that proper disclosures are made, and also wherever possible synchronization with the other regulation, especially our takeover regulations have also been done. We also try to streamline the delisting regulation by making it more robust, do the synchronization, making it more efficient, making it more transparent and investor friendly. We also try to plug the gaps because we found that there is a possibility of misuse wherein the delisting has been announced and actual delisting has not taken place. So the promoters should not be allowed to misuse the system of delisting and jacking up the share price. So we try to plug the gaps, and possibility of misuse is also curtailed. Further, we found that there are some references in the regulation wherein Companies Act and the regulations which have been discontinued are still there. So those updation was also needed to make this an updated and smart regulation. So in view of the same, these 23 regulations were also discussed with our primary market advisory committee, which consists of various market intermediaries and stakeholders. And they were thoroughly, after discussion and after incorporating the suggestion received from the market, we have now circulated this for public at large. And the consultation paper is available on SEBI website. The last date is 21st of December. We invite comments of the public. And through this seminar, if any further comments are received, we welcome that. Thank you so much.
Okay, thank you, Achalji. Thank you for giving the overview on this. Now, friends, what we are doing, this consultative paper, Anjali will present, because this consultative paper is divided into 6 parts, which Achalji has just now mentioned. They want to enhance the disclosure, refine the process, rationalize the timeline, streamline the delisting process, plug the gaps, and update as per the Companies Act, another securities law, which has taken a change and which is impacting this. So now I will request Anjali to one by one, as per the consultative paper, what is the present law, what SEBI is proposing, and then I will ask Achalji on each point that what is the thought process of SEBI to bring out this change. Some changes are welcome, which you can read and understand, but some changes are technical in nature. There may be some background. So we want to understand from your side. Over to Anjali, please.
Thank you so much, sir. At the outset, I'll thank Achal sir to give an overview and the SEBI's intent behind coming out with this consultation paper in the delisting regulations. As told by Pawan sir as well as Achal sir, we over the years, even we as merchant bankers were feeling that there is a requirement of changing the law. There is a requirement of bringing in certain amendments, keeping in mind the changing scenarios. So in this presentation, as Pawan sir said, that I'll be try to compare the present law vis-a-vis the proposed amendments. Before proceeding with the comparison, I'll first like to run through the present delisting process, which is there in the delisting regulations under the present scenario, so that we can better understand and we can better assimilate the proposed amendments. So under the present delisting regulations, the process primarily consists of the company receives a delisting request from the promoters or the acquirers. The company has to appoint a merchant banker to conduct a due diligence. This due diligence pertains to trading by top 25 shareholders and the promoters during last 2 financial years, during last 2 years from the date of the board meeting. Then the merchant banker submits his report. A floor price is determined, and then a board meeting is held wherein the delisting proposal is approved. The shareholders' approval by way of postal ballot is sought. The company applies for in-principle approval to the stock exchanges. Then the escrow account is needed to be opened, wherein the issue consideration is needed to be deposited. Upon receipt of in-principle approval, within 1 working day of the receipt of in-principle approval, a public announcement is needed to be made. And then of the public announcement, within 2 working days, the letter of offer is needed to be dispatched to all the shareholders. Within 7 working days of the public announcement, the offer is needed to be opened. Offer is needed to remain open for a period of 5 working days. Then upon closure of the offer, within 2 working days, if the promoters feel that the floor price, the final price determined by the shareholders is comparatively on a very high side, they have the option of giving a counter offer, which can be made within a period of 2 working days, on the basis of which the final delisting price is determined. Then a PA, public announcement, within 5 working days is needed to be made for success or failure of the delisting offer. Within 10 working days, the payment of the exit price is needed to be made in case of success of offer, and in case it is the offer is a failure, or in case there is failure of the offer, the shares are needed to be returned to the shareholders. And a final delisting application may be made within a period of 1 year from the passing of the special resolution. And then the stock exchanges grant their final delisting order. So this is the broad activity schedule. So now coming to the comparison of the present norms and the proposed amendments. As discussed by Achal sir as well as Pawan sir, the entire discussion paper is divided into 4 or 5 segments. First one relates to the proposals to enhance the disclosure requirements so that the investors can take a well-informed investment decision. So the basic step, the first step is the promoter's intent to go in for delisting. So presently, as I discussed in the sequence of events, the promoters or the acquirers inform the company that they want to go in for delisting of the company, which later on is approved by the board of directors of the company. So it is proposed that the promoters or acquirers shall, on the same day on which they inform the stock exchange, on which they inform the company, they should give an initial public announcement to mentioning therein their intent of going in for delisting of the company. This is needed to be done on the same day. This IPA, initial public announcement, is needed to be made by the promoter through the manager to the delisting offer. That means a merchant banker is needed to be appointed by him upfront. And this IPA should contain the reasons for the delisting, the compliance with the provisions of Regulation 4.1A, 4.4 or 4.5 of the delisting regulations. 4.1A is no sale by the promoters or promoter group during preceding 6 months. 4.5 is the promoters should not have used any artifice or scheme to ensure success of delisting. This is a comparison of the present norms and the proposed norms pertaining to the delisting intent of the promoters.
Okay, Achal sir, now over to you. We just want to understand that this proposal, because if you see the delisting process, it is a long process. First, the acquirer will talk to the board, then board will call the shareholders, approve after the approval shareholder meeting, and various other process. So you have proposed this initial public announcement, IPA, on the same line of takeover offer. What is the background of this? So please explain to us.
Yes, Pavanji, you have rightly said that we have tried to synchronize the requirement and delisting with that of the takeover. The thought process is that as soon as the promoter has given its intention to voluntarily delist the company, this become a UPSI, unpublished price sensitive information. And when this information is available with the public, we don't want that this to remain with the company, and possibility of insider trading is there. So we want this information to be immediately be disseminated to stock exchange, so that every stakeholder, every shareholder should know that promoter has decided for the delisting, so that possibility of information asymmetry is not there. All investors are able to take an informed decision on the basis.
Okay, now in this case, when you are giving IPA, have you thought that at that particular time, the the acquirer should inform the price also, or just he has given his intention?
No, price is not decided. So because price is to be decided subsequently, because when company decide, then only the issue of price will come. It is only the intention which is important, and then that need to be told to the public at large. And the pricing floor price is usually calculated on basis of the takeover regulation, which is already there. So public can know that what would be the floor price, and the offer price or the indicative price which their company want, they can, that depends on company. So that will be decided subsequently after the company's approved.
So can you make this IPA can have a floor price, because floor price is not the indicative price which you are talking about, is something different. It is on the base formula based. So that can be the part of the announcement. Did they?
Pavanji, this issue was deliberated, and the issue was, unless company decide for the board of the company decide the issue delisting on the delisting offer, the price cannot be mentioned, because that will be giving a wrong signal to the market. So it was agreed that it should not be insisted upon.
Achha, when we are talking about the acquirer and promoter, so the acquirer and promoter may be different. Majority time promoters, because they have to reach to 90%, so the promoter has to come out. Have you come across some cases where acquirer and promoter are different?
And this is with respect to 5A regulation, 5A or takeover regulations.
Yes.
So whenever there is a takeover offer which is combined with the listing offer, the person is called acquirer, because he is not the promoter, right? Presently, generally.
Okay. Achalji, now this IPA has some information like reason for delisting, compliance with the provision of the delisting regulation. These things you want to ask them. So
Okay.
Reason for delisting, have you thought of, or are the SEBI is planning to give some format, some information which can be done, or you will leave to the acquirer that he should inform?
We will leave it to acquirers that they should provide this, because every facts of the case will be different, and let the acquirer or the promoter decide what are their reasons for the delisting.
Okay. Any other point, Anjali, and want to add this? Manoj, you want to add in this?
I think, sir, one thing with respect to the floor price to be disclosed in initial public announcement, I think that much we may require disclosure, because in case of 5A offer, the takeover offer price becomes the floor price. But so it is in public domain, whereas in case of other delisting offers, it will not be in public domain. So there is a difference between the disclosure requirement in two cases. So I think we can make symmetry, and floor price, because it is formula based, it should be disclosed.
That will create unnecessary confusion in the mind of public, because price is very dynamic and subject to change. And why to create this confusion when is the floor price to be calculated is clearly specified in the regulation.
Clearly defined.
Date is different, yes. So we have to change that way if we want to make symmetry.
Okay. So now, thank you. Now, Anjali,
one thing which is coming to my mind, that because the promoter is giving his intent to go in for delisting, and a merchant banker has already been appointed by him. As Achal sir said about the UPSI, so Trading window will also be needed to be closed for this purpose, because trading window closure happens from the company's end. But presently, till now, company is not aware that there is a possible delisting in the company.
Actually, I think trading window issue is we can flag this. That
I mean, they can keep in mind.
So
right.
Go to the next point.
Right. Now, approval by the board of directors. Under the present scenario, the process flows like this: that the promoters give his intent for the delisting offer, the board considers the same, the board appoints a merchant banker to conduct the due diligence, who gives his report, and the board thereafter approves the delisting. So, in the entire sequence of events under the present regulations, timelines have not been mentioned herein, that within what time the next step has to happen. And in the proposed delisting regulation, in the proposed amendments which are proposed, so this loophole is tried to be plugged in, wherein it has been mandated. It is proposed to mandate that the promoter will give his intent for the delisting offer to the company, plus they'll issue an initial public announcement. The board of directors will consider the same within a period of 21 days. This is proposed to be included therein. Then the merchant board will appoint either a merchant banker or a PCS, wherein again an amendment is proposed for conducting the due diligence, who will issue his report, and then thereafter the board will approve the same. This DD certificate, DD report, and this report for share reconciliation will be disclosed to the stock exchanges for public information. This particular point was not there earlier, but now it has been proposed to include and inform the stock exchanges for public dissemination.
Okay.
So,
okay. Now, Achalji, this point this is a welcome move, that all these things in delisting guideline as compared to takeover is on date wise. This event and that event and after that. But here there was an open-ended thing. So you have come out the now dates. That is, what is other thought which you have thought relating to due diligence and relating to due diligence certificate to because you have also thought that merchant banker is doing the offer and he's an interested party, so it should be done by the practicing company secretary. That is also welcome move because it's a part of this. So what is the thought process in this and what you want to achieve?
You have rightly pointed out, basically there are two parts to this proposal. Right now, there was no timelines. So we want to give specific timeline. It should not be the case that that company take their own time for board approval. And also disclosure need to be made of the due diligence report, wherein whatever the requirement of last 2 years trading by the promoters, top 25 shareholders, etc., need to be disclosed. Also, the audit report of share reconciliation by matching it with the depository record, that need to be done. Though this normally report is done on a quarterly basis, but we want that even before the delisting, this need to be disclosed so that the shareholders are able to take an informed decision. The basic purpose is to empower shareholders so that when they go for delisting, deciding for delisting offer, they have all materials in their hands and they take a decision thereafter on basis of the same.
Okay, Achalji, now the due diligence, will you prescribe this format and the certificate and audit?
No, we are not prescribing any format as such. We have only said that basically for due diligence, merchant banker due diligence report, basically they need to make a disclosure, but the format is we have not prescribed.
But when you say the word due diligence create a confusion that what types of due diligence, because due diligence has a multiple type of due diligence. So is it not a good practice that you give a broader aspect that what they have to cover in the due diligence?
No, that has been already been prescribed, that what is there to be expected in the due diligence. I have already mentioned that record of the trading by promoters and top 25 shareholders in last 2 years that need to be mentioned. So giving a specific format may lead to tight jacketing the entire thing. The basic spirit is there, and we want that the merchant banker should give the same in letter and spirit, whatever is expected from them. Being professionals, they are understanding the requirements which has been cast upon by law, which SEBI intend to put this, and they need to comply with the same while giving their reports.
Okay. Anjali, next point, enhancing disclosure.
Yeah. So refining the role of the board of directors or the independent directors, this is a welcome move, which this provision was not there in the earlier delisting regulations. As contained in the takeover regulations, a committee of independent directors is needed to be constituted. This committee will give the justification for the delisting offer, and simultaneously the voting pattern of the independent directors committee along with the justification is needed to be published in the newspapers and also disclosed to the stock exchanges. So,
Yeah. So, no doubt, you are giving more responsibility on independent director. That is a welcome move. But, and then you have also mentioned that they can appoint a outsider and they can pay that cost to that. That is also a welcome part and clarity. What is the what you think that this institution of independent director can solve this problem, or what problem you have faced earlier?
The issue here is that independent directors, the duty which has been cast and for which they are on the board, they can give, they can justify their role by giving their recommendations, whether they agree with the delisting proposal, and they can take the opinion of some outside expert which they want to take, and also their voting pattern also need to be disclosed to the shareholders, so that shareholders, while deciding on the delisting offer, are aware that the independent directors which has been placed on the board of the directors have this view, and even after taking the views of the expert, their view is formed with this recommendation. So that will help in arriving at some decision by the shareholder.
Okay. Manoj, in takeover law, you have the independent director's report is going and it is going in the newspaper also.
Right.
What is your experience and what do you think that the delisting regulation should also include?
So at present, this IDC concept is there, and that is in many of the cases is not much effective. It is just a formality. But in some cases, yes, the independent directors are proactive. They have appointed independent merchant banker, take in consideration about the valuation aspect and compliance aspect also. We have also been appointed in some cases, and we have given our recommendation in the presentation form, because sometimes the independent directors are not well aware of the law and process and valuation parameters, so they will need to understand that. So if they effectively understand the process and then the valuation parameters what has been taken, then certainly they would be able to justify their role as a independent director to protect the interest of the public shareholders. But sir, I have a bit of doubt in this case. In the recommendation, we are talking independent directors committee to be appointed beforehand, before the board of directors is getting up. Taking decision on delisting. At that time, pricing is not there, valuation is not available, and so it, without knowing at what value the promoters or the acquirer is willing to give exit to the shareholders, what kind of recommendation effectively they could be in a position to give. So that will be a big challenge. What is the right exit price? That is a critical aspect in case of any delisting. Otherwise, obviously, any company, you can continue in a listed company and get the valuation in the market, liquidity in the market. So if you are talking about exit, what is the most important parameter? That is the price at which you are getting the exit. So without that, what kind of recommendation they would be in a position to give is a thing to be thought of.
Manoj, I think here in the time of having this meeting, this is before the publication, after the public announcement, at what stage should this meeting be held?
Yeah,
That would
that is
help.
the challenge. That is the thing
That is,
which is critical. Whether it's
I can echo, because we have seen the independent director's recommendation in takeover is a formality, but delisting cannot be a formality, because the open offer, if you are not giving the offer and you have not participated, nothing is losing out. Here, the recommendation of the independent director is more important than the takeover offer.
very right.
Very right.
Delisting is in the interest of investor. Floor price is fair. Indicative price is offered is adequate premium or not. Precondition to claim exemption has been complied. No scheme or arrangement misuse doing this. All these points has to put before the independent director when they are suggesting that this is in favor of investor, to tell them. It's a big task, and that has to you have to give a proper guidance to these independent directors things.
Yes, that is what I'm saying. Even in many of the cases, independent directors would not be in a position to justify delisting. So they would give
negative report.
Negative report, or even not, they will bypass those things, critical aspect, and simply say that subject to compliance of applicable laws, you have to take a informed decision and this that.
Sir, your point.
Effective recommendation anyway.
Sir, your point.
I note whatever the suggestions which you are giving. We will deliberate the same after after public comments are received on the basis of the suggestions received.
Okay. Anjali, next point, this refining role of board of directors.
So the next section of the consultation paper is refining the delisting process. Presently, the shareholders' approval is needed to be obtained by way of postal ballot. It is proposed that this shareholders' approval may be obtained either by way of postal ballot or by way of e-voting. As we all know, postal ballot is a process of at least 30 days. E-voting mandates only for 3 days. So if the company decides to go in for e-voting, there will be a reduction of timeline by almost 26 days. This is a welcome move if this can be allowed. But I just have a small doubt, will 3 days be sufficient to take an informed decision by the shareholders? That has to be seen by regulator.
Sir, what is the any thought process to convert this? No doubt this timeline has reduced. Any other point you have thought out, sir?
So basically, the purpose is to bring in efficiency. But yes, whether the postal ballot and or e-voting is to be permitted by the company as per the provision of the Companies Act. So if the law permits, then it can be postal ballot or e-voting. So we are giving an option to the company so that to facilitate the process of delisting. As Anjali has rightly pointed out, that will help in reducing the timeline in a substantial manner.
Anjali, next point.
Yeah. A new concept of indicative price. This till now has not been there in the delisting regulations. What was seen that in few of the delisting offers, indicative price was mentioned. So it is proposed that this indicative price should be more than the floor price, and this may be specified by the promoters or may not be specified by the promoters in the public announcement. This is a very short proposed amendment.
Yes, sir. What is the background of this indicative price and how this word indicative price has come out?
Pavanji, we have seen in past few delisting offers wherein companies on their own have come out with the price which is above the floor price. Let me give you an example of Hexaware, wherein the floor price was 264 and the indicative price was 284, which the company gave. Though RBB price came to 475 and the company agreed and delisting happened. So basically, this is a market practice which was already there. We are merely enabling that whatever is there in the market practice, so that that will help that wherein the promoter will come out with an offer of indicative price in the delisting, showing to the investors that they are serious about delisting offer and help in achieving the process and completing the same in a timely manner.
Okay, sir, are you making this because that is the regulation is silent? Suppose I'm giving, say, floor price is 250 and I'm saying indicative price is 280 and the 280 is coming and the promoter today, as per the law, promoter can say I'm not going for delisting. But when I'm giving 280 price, it is compulsory for me to take the shares at 280 rupees?
Yes. So once promoter has mentioned indicative price, that has to be complied with.
Okay, that is one part. Now, floor price is mentioned, that floor price as per the formula of the takeover regulation. Now, point is the takeover regulation and the buyback regulation, when we are doing valuation or giving a price, it is a price which is continuation, that company is continue. But when you are giving delisting, it means company will not continue. So it is not that a good idea that floor price should be on the basis of SEBI takeover regulation plus 25% above the ST rate or book value, whichever is higher.
You see, Pavanji, floor price is only the floor price below which it cannot go. And that is the basis which is coming out from the takeover regulation. Now, we are giving an option to promoter to increase the price, given a price which is higher. It may be possible that the book value or the fair value will be much, much higher than the floor price. But this is only the floor price. Actual price or delisting price may happen at much higher price. And that need to be determined through reverse book building.
Okay.
So one small concern here. Can the final delisting price be less than the indicative price?
No.
No, right. Okay.
Next point.
Yeah. Now, few of the certain important amendments which are proposed is with reference to the escrow account which is needed to be opened. Under the present scenario, the sequence of events remains that the company needs to open a escrow. The acquirers need to open an escrow account, deposit there in the issue consideration, being the floor price multiplied by the outstanding number of shares with the public. In principle, application with the stock exchanges is needed to be made. In principle, approval from the stock exchanges, and a public announcement is needed to be made within 1 day of the receipt of in principle approval. Now it is proposed that a escrow account is needed to be opened within 7 working days of the shareholders' approval. Deposit therein at least 25% of the issue consideration. Balance to be deposited before the public announcement. However, if there is a failure of the delisting offer, 99% of the funds to be released within 1 working day of the public announcement to the promoters. Balance 1% will be released only upon returning the shares to the respective shareholders.
Sir, what is the logic that currently it is 100%, now you are bringing out 25%? It's a good move on that aspect is good. But what is the thought process and how this will helpful to the entire delisting process?
So, Pavanji, our thought process is to ensure that this process is completed as early as possible. When promoter is bringing in is 25% money within 7 days, that will show to the investors that promoter is serious, and that will help in reducing the time gap and completing the process as early as possible. So that is the actual objective. And 25% is to be given within 7 days, and balance 75% before the RBB, as was earlier.
Sir, if you see the today's scenario, it is happening that because delisting process is a long process. So many companies, promoters, first they will give offer and then they will search money for giving offer. So are we putting any restriction on this, that they should not do window shopping, or they should not, they are offering and then they can withdraw? Certain restriction you are putting on them?
Pavanji, our purpose is that the process should complete. Promoter should go for delisting offer if they are serious. It should not be the case that they only for the management of the share price in the market come out with the delisting offer wherein they are not serious about the delisting. By putting in 25%, public at large is aware that they are serious, and they will, then the entire stakeholder will ensure that the process is ended. And when the skin in the game of the promoter by 25% is there, they will also ensure that the entire process is completed in a time-bound manner.
Okay, okay. Manoj, you want to add something?
Manoj, you are muted.
Yeah. So I think 25% commitment from the promoter is logical. It is in line with the takeover regulation, where any person is coming into a listed company and they have to put at least 25% of the offer size in the escrow. So that should be sufficient commitment from the acquirer or promoter side. So that is there, and at the time of public announcement, they are asking for 100%. So that would also be perfectly all right. With respect to refund of the money, I think that is also logical, because most of the shares will be in demat form. So refund would not take time, only minor shares maybe in the physical form. So 1% security is sufficient for that also.
Okay, okay. Next point, Anjali.
Yeah. So the reverse book building process, presently there is no mention in the present regulations with regard to the fate of the delisting process, book building process. And another thing which was observed by SEBI was that even the unconfirmed bids appear on the stock exchange window, on the RBBS window of the stock exchanges. So it is proposed that within 2 hours of the closure of the tendering period, the outcome of success or failure is needed to be announced, for which presently there is no time frame. And the unconfirmed bids or orders should not be appearing on the stock exchange's reverse book building window. I think both these suggestions are a welcome move.
Okay.
Should be implemented.
Sir, your take on this?
As Anjali has rightly mentioned, since it was not mentioned earlier that public are aware whether the delisting has been successful or failure, and they are at loss. So immediately within 2 hours of the closure of the RBB, the fate should be known. And as far as the display of unconfirmed bids, we saw in the recent big delisting offer, there was a lot of confusion regarding this. And this has emerged because as per the extant law, no last day modification is possible in the bids. And when some technical error has happened because of wrong punching of codes by the brokers, the orders could not be altered. So those orders which could not be altered remain in the system and remain as unconfirmed bids. So though the same investors, by way of separate orders, had put in their orders which were duly executed, but the orders which remain in the system and remain as unconfirmed was giving a wrong impression in the eyes of public, that as if because of this unconfirmed orders, the delisting offer could not succeed. So this type of situation should not be allowed, and such unconfirmed bids should not be shown to the public, because actually these are not the true orders. So it is because of the system that this situation is there. So we are ensuring that no display of unconfirmed bids should remain in the RBB window.
No doubt, sir, this RBB window is a unique concept of India. And I am aware that one of the person who has developed this ex-SEBI official, Mr. Bindalesh, is also participant in this thing. That time he was in charge of this division. He has introduced this this concept in consultation with everybody. So this is a very unique point, and which is very successful and very investor friendly. Anjali,
Yes.
now
Yeah.
time is short and we cannot, so all points which are normal, okay,
Okay.
just
Fine.
tell us, don't go for detail,
Right.
just tell us these are the changes. And Achal Singh sir, if some point is not a debatable and which is a welcome, this is a normal, we can go ahead, because I am receiving 15-20 queries also, so we have to ask that. And some point which SEBI has not covered, that Anuj has prepared a note also, we have to discuss that also. So Anjali, any point which is welcome move, you can just tell us, and Achal Singh sir can also pass on.
Fine, sir, understood. So the next section is rationalizing the timelines, which is a very important aspect. So again, the timeline for in-principle application and the final applications. Under the present scenario, shareholders' approval is needed to be obtained. In-principle application is needed to be made. But again, no timeline has been specified under the present norms. Public announcement is needed to be given, offer to be made, and final application. Now, this is a very important aspect of the present regulations. Final application can be made within a period of 1 year from the shareholders' approval. It is proposed to curtail the timelines, wherein proposal is shareholders' approval is needed to be obtained. In principle, application is needed to be made within a period of 15 days from the shareholders' approval. In principle, approval has to be given by the stock exchanges within a period of 15 days. Presently, it is 5 days, but it is felt that 5 days is not sufficient. So within 15 days, they have to give the approval. Then public announcement, offer and payment is needed to be made. Then final application is needed to be made within a period of 5 working days from the payment to the shareholders. So
Yeah. So Achal sir, I think these timeline are good. Are you want to add anything on this? If it is.
No,
Okay.
Pavanji, I think these are self-explanatory. The purpose is to reduce the overall timeline for delisting. And wherever it was not specified or unnecessarily long, we have tried to curtail the same so that the process is completed in a time-bound manner.
Good.
sir,
Okay.
I have a small suggestion here. In our experience as merchant bankers, what we have seen is once the payment is made, the promoter wants to file the final application immediately. But delay happens because they do not want to open the offer. So if we can curtail that time, say from receipt of in-principle approval, within a period of 30 days, you have to open the offer. Automatically, the entire sequence of events will get curtailed.
I think Anjali, you can give suggestion on this, because something
Fine,
which is
fine.
something which is
Right.
For the benefit of every participant, we must focus on this.
Fine.
Yeah. Next point.
Now, tendering of shares under the present norms, the shares may be either deposited in the special demat account opened by the merchant banker, or a pledge or lien can be marked in favor of the merchant banker. And in case the promoter does not accept the final price, then these shares are needed to be returned within a period of 10 working days from the closure of the bidding period. This is proposed that the tendering to be done through lien, and in case the offer is not successful, then the shares created through the lien are needed to be released on the same day on the closure of the offer. This again, I think, is a good move.
Yes, sir. Any experience on this?
Again, Pavanji, we want that movement of shares to be avoided to bring in efficiency in the process. And in fact, you must be aware that recently when in the margins also, we have introduced this concept of shares to be pledged. So this concept of lien is a new concept, and I feel that it is in the interest of the shareholders.
Okay. Manoj, any experience, any things?
Sir, I think it is a very good move. Very much similar to ASBA, where money is not moved. So now majority of the shares are in demat form. So this is a very good move.
Yeah.
Okay, Anjali, next point.
Role of the merchant banker. Presently, there are two provisions which define the role of the merchant banker. First is the due diligence aspect, which is the company wherein the company is needed to appoint the merchant banker. And the second is the merchant banker to be appointed by the acquirer for offer management. These two merchant bankers may be same or may be different, but it is proposed that the acquirer will appoint a merchant banker for offer management, and the due diligence aspect may be undertaken by a PCS in place of a merchant banker. The PCS should not be related to the merchant banker or the acquirer or the promoters.
I think this is also a good move. Sir, any point on this?
Pavanji, we want to bring in and ensure that the merchant banker, as in case of SAST, is clearly specified here also. And also there is no conflict of interest, because for due diligence, they are acting at the behest of company, and for offer, they are doing on the behest of acquirer. So due diligence work is more akin to sectorial audit, and they should be done by a practicing company secretary. So this is a new avenue for practicing company secretary, which we are opening. And that will help in more company secretaries also being involved in this process.
Okay, I think this is a good move, and this will help us, help the coming out. Only my suggestion is one to Sir, to SEBI, that the due diligence, when we are saying due diligence, the broader aspects you must, because secretarial audit is more towards the company law. So no doubt the secretarial auditors see the security law, but if you can focus that these are the 7 or 8 main points which they have to see, it will be helpful. Otherwise, they will do due diligence from that side to that side, and there will be confusion. So you can identify for this due diligence, you want to see following things. It will be very helpful. Anjali, next point.
Yes, sir. Under the present norms, there is a provision for providing exit to the remaining shareholders, that is the shareholders who have not tendered their shares during the delisting offer. This period remains open for a period of 1 year from the date of the delisting, but no modus operandi of the same has been mandated. So it is proposed that the merchant banker or the promoter is needed to take the following additional steps. They need to submit quarterly progress report to the stock exchanges as to what all shares have been tendered during the quarter. They need to send follow-up communications to the remaining shareholders on quarterly basis. And even a newspaper advertisement is needed to be given to the remaining, for the information of the remaining shareholders on quarterly basis during this 1 year exit window.
Okay. Sir, I think this is very, very important investor-friendly move. So please suggest what is the thought process is going on.
The thought process is the same, that we want that even after the delisting, the 10% shareholder who could not offer the shares because of some reasons, they should also be provided an opportunity to offer the shares during this 1 year subsequent to the delisting. And company acquirers should take active steps to ensure that the payments is made, and the shares, they get their dues, whatever is available as per the law. And merchant bankers should facilitate in this process, because they have been in active association with the promoters, and they should continue to with the same subsequently also.
Sir, for this particular purpose, the 10% shareholders which are not coming forward, or 8%, the point is very clear that this should happen, but this SEBI should put the responsibility of somebody, maybe company, maybe acquirer, maybe merchant banker, maybe stock exchange, that they should, two things is, one is monitor, one is the action. So company and acquirer should take action, and the stock exchange and merchant banker should monitor this, that you can make it more stronger, which should be good for the investor point of view.
Pawanji, we have already mentioned that stock exchange would monitor the compliance, but the acquirer and merchant banker should jointly work toward ensuring that disclosures and file quarterly reports, and ensuring that the remaining shareholders are given an exit opportunity.
Okay, Anjali, next point.
Yeah. There in every company there remain certain inactive shareholders. So in case the shareholders are vanishing shareholders or vanishing companies or struck off companies or shares have been transferred to IEPF, it is proposed that while calculating the 90% threshold under the reverse book building process, the same shall be deducted from while calculating the 90% mark. I think again a welcome move. This was the need of the hour.
Sir, there is one technical issue. The shares transferred to IEPF, and you are not calculating this. And what is the because vanishing company, struck off company, that is their own fault. But share transfer in IEPF is acting as a trustee. And once company is delisted, then their share price may be worst, and they will not pay them. And tomorrow I'm going to IEPF and claiming my share. That time they can give my unlisted company share. So the question is, should you not work out some other mechanisms for share transfer to IPF, that company should, the acquirer should pay money to IPF, and they can, whenever the shareholder of this listed company is coming, he can get the money.
Pawanji, I think 1 year time frame is already there, no? For
No, not for 1 year, sir. I'm just saying ki IPF shares you are saying, because that shareholder may come after 3 years or 4 years when he come to know, because he has not come for his last 7 years. So how we are expecting that within 1 year he will come. So tomorrow when the IPF shares anybody can claim, so that time he will claim only the unlisted company, and that company has no value, or the shareholder, the acquirer will not pay anything to them. That is the only point I'm saying. We must work out some different formula for this IPF share.
Pawanji, you give a suggestion, we will deliberate it.
Okay. Anjali, next point.
Yeah. Now, the next section, proposals for plugging in the gaps. As I discussed in the opening slide, there is a process of counter offers. Under the existing norms, there is no provision as to what should be the counter, as to on what basis the book value or the counter price has to be computed. It is proposed that the book value may be considered. There is a concept, counter offer cannot be less than the book value of the company. So it is proposed that the book value may be considered on both consolidated as well as on standalone basis, whichever is higher. This should be taken as on the latest, as per the latest quarterly financial results of the company, which have been submitted to the stock exchanges, and as on the date of the public announcement for the counter offer.
Sir, the thought for this and what is...
Pawanji, the thought is that after RBB has, the promoter don't agree to the RBB price and they want to give the counter offer, it should not be the case wherein the price is less than the book value, because that will show the seriousness to the promoter, to the shareholders also, that promoter has given a justified price. And it should not be seen as if the delisting process is going on and just for the purpose, for example, checking up the share price, and the process is shown as if there is high volatility in the market price also on account of this. So we want that the the counter offer should not be less than the book value. Though it has been mentioned, but the problem was what is the book value was not mentioned earlier. And now we are clarifying by way of this proposal, what is the, how book value is to be determined.
Sir, if you see the valuation can be multiple ways. If it's a listed company, the market price, sometimes market price is also less than the book value. And then sometimes the other method of valuations are also there. So is it not the correct way that the acquirer should give in consultation with merchant banker or valuer all types of prices, the book value, the market price, and the net asset value, or the other method, whatever prescribed. So investor has a rational decision and independent director is also having a better decision. Is it not the correct way to do this?
Pawanji, what we are suggesting, it should not be less than the book value. If you want to give higher price, it's up to, they are welcome. They want to let them give.
Okay, Manoj, you have any view on this valuation?
Sir, valuation, obviously, sir, book value is always a issue. The book value calculation is also very unique. Sometimes it is based on simply the net worth divided by number of shares. Sometimes it is calculated based on the intrinsic value of each of the investment and properties and then divided by number of shares. So we have to, I think definition clause is very important. We have to properly define and put the definition of the book value for this purpose. Also, I think what we are talking about quarterly basis. So in quarterly results, other than half yearly, there is no net worth calculation given. So person giving counter offer may not have sufficient data to determine the book value on quarterly basis. So we have to take care of that also.
So Manoj, what we are suggesting is that latest quarterly financial, that means latest audited or after limited review, whatever they're following. So they need to provide on that basis the financials. Now, if you want to give further suggestion for further improving or thing, you are welcome. You can give your public comments.
Sure, sir.
Okay. Okay. Anjali, next point.
Yeah. If the under the present norms, it's not mandated that if the floor price is equal to the reverse book building price, if the reverse book building price is equal to floor price, can the promoters still reject the offer? So it has been it is proposed to mandate that if reverse book building price is equal to the floor price, promoters will not have the option of rejecting the price. And the expenses relating to the delisting shall be borne by the acquirer or the promoter in case of failure of offer. Herein, I feel that floor price / indicative price should be there, because as I discussed with Achal sir, the final price cannot be less than the indicative price.
So now there is three price for this. One is the floor price, second is indicative price, third is RBB price.
Yeah.
So so you cannot reject from floor price or indicative price, and the RB price is the same as indicative or floor price, you can't reject. Is it right, sir?
Yes.
Okay. Okay.
So, and then, then the cooling off period between after the delisting, presently it is 5 years. It is proposed to bring it down to 3 years.
Sir, what is the background of this 3 years and 5 years?
3 years is because even if we consider that the cooling off period from after listing to delisting is minimum 3 years. So we want to align the same with for the companies which are going for after delisting want to relist. So basically 3 years from both the sides.
Okay. Sir, in some cases where the stock exchange has closed down and this was not any role of the company, in that case also we are saying that company is delisted. So I think you must see this if the stock exchange is closed down, and because of this you have made them the process that they will get that they have to pay the money to the shareholder and then they will be delisted. That should be treated separately, not as a this delisting, which has a restriction of 5 years.
So you are talking about regional stock exchanges,
Yes, yes.
erstwhile regional stock exchanges.
Yes, yes.
Yeah.
Yeah, you can give those suggestions. We will examine.
Yeah. Anjali, next.
So presently, it is mentioned that after a buyback process or a preferential allotment, delisting cannot be brought in. But no timelines have been prescribed. So it is proposed that the delisting shall not be permitted until 3 months have lapsed from the last buyback or the preferential allotment. This clarification was required. It's a good move.
Sir, there is one question also which I have received. They are saying 6 months is a very less period. It should be 12 months because delisting is not something which you are doing. Your comment, sir.
Pavanji, presently there is no timeline prescribed, and there was scope for varying practices also. So we have, after discussion with the stakeholders in PMEC, have suggested for 6 months time frame. But if public want to give another suggestion, they can give with their rationale.
Okay.
I think an offer for sale should also be included herein, because in few of the cases it was observed that the company was not meeting with the MPS norms, and to meet the MPS norms, it came out with the offer for sale, and within a short time they came out with the delisting offer as well. And SEBI mandated that the people who had acquired the shares in the offer for sale, they will not be allowed to tender their shares in the delisting offer. So maybe offer for sale can also be a part of this embargo.
So you can give that also in suggestion.
Yeah.
Thank you.
Yeah, Anjali, next.
Further, it is also proposed that in case of delisting of shares in the home jurisdiction of the company, the depository receipts issued overseas shall also be delisted. This is subject to the consultation with the Government of India.
Sir, any point on this?
The only thing was that in the SEBI circular of 2019, this aspect was not clarified, and so it was decided that wherever the company go for delisting of shares, and you will appreciate that there are two issues. Requirement of 10% also, 90% also need to be achieved. Now, if we take the example of, say, Infosys, wherein almost 16% shares are held by way of DRs, that delisting cannot happen unless it is through DRs. So, this is a proposal that once delisting of shares is there, the listed company which has by virtue of the listing has also taken DR listing overseas should also get the DRs delisted.
Okay. Next, Anjali.
Yeah. Cooling off period between two consecutive delisting offers. Under the present regulations, there is no such provision, but it is proposed that there must be a gap of at least 6 months between two consecutive delisting offers.
I think this point, Achalji, you have covered. Now, sir, Achal sir, any other point which you want to highlight this?
Only, Pavanji, these have broadly brought out all the points, which are the key points which are there in this. And I will request that public at large should see our consultation paper and give the comments thereon.
Okay. Sir, now there are certain points which are not covered in the delisting regulation. I will request Anuj to just tell some points which are there, which this consultative paper is not covering, or delisting regulation has some issues. Anuj, please.
Yeah, good evening, sir. So the first recommendation with respect to the offer period, which is given in delisting offer. So generally, when company is offering exit through buyback or new acquirer is giving exit through takeover, the offer period that is given is minimum 10 working days. In delisting, when whole company is going to be get delisted from the stock exchange for once and for all, the time period for the offer period is given only 5 working days. So in recent case also, we have seen that due to some unconfirmed bid, the whole delisting exercise, which has took along, I think, 6 months to prepare, and got failed just because of some unconfirmed bids. So these little hurdles can be avoided if the offer period can be extended a little more. Because once the company prepared for delisting, it's a very long exercise, and just because of some 1 or 2 days extra, the delisting, the whole exercise got failed, is actually a problem to the acquirer and to the company, and also to the shareholders, because they may get a better value for their shares. So this time period for tendering may be extended a little bit, let's say just like buyback and takeover.
Anuj, firstly, let me clarify that what you are referring is unconfirmed. Because of unconfirmed bids, this offer could not be successful is factually incorrect. In fact, you may refer to BSE clarification, which is there available on their website. So it is not the factually correct statement. As far as your other point that the 5 days is very less, we also don't agree with the same. This is well publicized, and our shareholders are made aware of this, and 5 days are more than adequate, and we don't agree that there is need for more than that period.
Okay.
Okay. Anuj, next point.
Yeah, next point is with respect to streamlining the process for small companies. We have seen that there are so many welcoming steps taken by the SEBI in with respect to RBBS process. In the same line, the need is also there to streamline the delisting process for a small company which are listed on, let's say, Calcutta Stock Exchange, Metropolitan Stock Exchange, and they are not coming. So many companies are having large number of shareholders, because some companies are migrated from regional stock exchange to the MSCI or BSE. So these large number of shareholders are also are in physical form, and they are untraceable. So arranging the consent in terms of 90% of paid up capital is a little cumbersome for these companies. So we have seen some cases where a large number of, earlier it was number of shareholders. The consent from 90% of number of shareholders was required. This has been changed to 90% of the paid up capital consent is written consent is required. So now we request that there should be some treatment of untraceable physical public shareholder for the small shareholders, small companies.
Actually, same point like you have done the vanishing company and IPF and the strike off company. Same way, there are so many shareholders which have applied and they are not available. So if company can prove that these are the efforts they have done, so that can also be excluded in this.
Pavanji, there is a provision in delisting regulation for regulation 25A, wherein we provide that if the company requests for exemption from certain clause, they can request SEBI, and by proving the facts of the case. So there is no need for providing a specific provision for untraceable. Let them come to SEBI and explain with the facts of the case. Then we will examine and decide.
Okay. Okay. Anuj, any other point? Otherwise, I can take some cases. Sir, Achal sir, there are some public queries also,
Yes,
which I'm asking. Other than this, there is a one complaint relating to one company. I will forward to you. So please help this investor who is asking the Secure Earth Technology Limited, some shareholder, they are there. So I'm not taking up this matter. I'm just, if the volume of trading is very minimal, cost of compliance is very high. This is one comment somebody has given. What is the easy way to get the share delisted? So they are saying the delisting process, the entire cost process is there, and there is no trading in the market. So how to reduce cost? That is one aspect which SEBI can look into this. Another is, why does the delisting require 90% shareholders? Once a special resolution has been passed, why should there be any 90% minimum requirement? This is the question, sir.
Pawanji, first of all, delisting is like a divorce. Like listing is a marriage, delisting is a divorce. And in listing, the premium is decided by the promoter. In delisting, the premium is decided by the shareholder. And what best can be done is only through the reverse book building process. So it is they who decided for the same, and it is very transparent mechanism. And so we don't want to tinker with the same.
Okay, sir, but there is a two suggestion has come. Somebody is saying that please SEBI should provide the checklist for due diligence by PCS. That is one suggestion, so that we will send it to you. One is somebody is asking what happens after the 1 year period to the shares not tendered by inactive shareholders. So 1 year period you have given, and he is going after 2 years. So that company is delisted. You are saying the company is delisted. So what will be the fate of that shareholder?
Pawanji, law is for those who are vigilant about themselves and their rights. Regulators and law cannot help those who don't want to care about their assets. So we are providing 1 year, which we feel is more than enough after the company has delisted, and we don't see a reason for giving protection for those shareholders who don't want to take care of their assets.
That is right, sir. But we must come out some solution for more than 1 year, because we are working out. So some issue, SEBI can think on some innovative thing that this period 1 year can be 3 years, or 1 year period can be 2 years. Some more methods we can work out, sir. Okay, sir. Some few questions I have received. The small companies delisting, nothing is covered in this particular regulation, and there are so many issues. So they are saying, please look into that small companies delisting issues also.
There is already a law, Pawanji. We have already mentioned that for small companies, they need not follow the RBB, and the criteria is already clearly specified. So I don't see a reason for change in the same.
Okay. Second is, one question is compulsory delisting by the regulator or by the act of law. It's a loss to the investor, and investor is not getting anything. You are saying the promoter is devoured, promoter's shareholding is freeze, but investors are not getting anything. Something should come out when the compulsory delisting is taking place in favor of investors.
Compulsory delisting is done by the stock exchanges.
Yeah.
So it is on the ground which has been prescribed by Government of India in SCRA rules. So if the company chooses not to comply with the same, stock exchange are well within their rights by passing an order to delist those companies.
Okay. Okay.
So may I add?
Yeah, please.
Yeah. Even for compulsory delisting, there is a provision that the promoters have to pay the fair value which has been determined by the stock exchanges. So that exit opportunity mechanism has been prescribed.
Okay. Sir, one question is that there is a voluntary delisting, but there are some other method also through takeover or through merger. So Manoj, can you just explain that through takeover and through merger, delisting is taking place? Any modification is required in this?
Sir, with respect to delisting through takeover, we have already discussed. Regulation 5A was inserted in 2015 in that SEBI takeover regulations, which provides the acquirer to give its intent that they want to keep the company as unlisted company if they have such economic interest, economic logic. So they will give the public announcement as per the takeover regulation, because they are not part of the promoter group, existing promoter group. So they will give the open offer as per takeover regulation and indicate its intent And after the indication of intent, the process of delisting will start from the public and detailed public statement. And if it gets successful, the delisting process becomes successful, company get delisted. If it fails, then again the acquirer has to come back to the takeover process, and the necessary protection is also there that the gap, the time period lapse here has to be compensated by the acquirer in the form of interest on the price determined earlier. So that is already there. There is also a very few cases. Generally, SEBI does not allow delisting through merger or under the company law. Though Companies Act has an enabling provision, if in case a listed company is getting merged into unlisted company, and it cannot automatically get listed. For that, they need a 19(2)(b SCRA 19(2)(b) exemption from SEBI. So if that is there, then it will be listed company. The new unlisted company becomes the listed company. But if that is not happening, then exit opportunity must be given as per the SEBI norm. So SEBI has not specifically provided any norm. So right now, generally, stock exchange and SEBI does not allow merger of listed company into unlisted company. There are very few exceptions. Like in one case, I think Precision case is there, recently happened, where the company was very small in size, and there was no trading in the company for last several years. So in that case, SEBI thought it fit to allow the delisting through merger of listed company into unlisted company, and allotment of redeemable preference shares, which they thought is a fair exit opportunity. So these are besides that, there can be a delisting under insolvency law, which is exempt from the delisting regulations. So these are the basically scenarios where delisting could happen without following the delisting law.
So you want any changes required in the delisting guideline related to this?
I think all other things are fine. IBC insolvency law, they have already covered properly. Exemption is there and protections are there. Only thing is, in case of solvent companies, merger, demerger, there is no specific law. Company law has enabling provision. They say that fair opportunity.
So actually, the point Manoj is saying that the merger, delisting through merger, that law is there in company law. SEBI should also come out. If you are going for delisting, you can put that through merger, you can do delisting, but you have to follow these guidelines and these these process, because it's a court route. So sometimes court is approving because of the company law. So that SEBI can come out some good way. So that is also another restructuring process of listed company where you can protect the interest of the investors.
Pavanji, I understand that there is some SEBI circular issued under LODR for the same. But is there a reference needed in the SEBI delisting regulation that can be debated and deliberated? Okay. You can make a reference for the same.
That the SEBI circular with respect to 92 talks about only the listing through the scheme of arrangement. So it may be due to demerger of listed company to new company arises, it should be given opportunity to get listed. But or if a listed company is merging into unlisted company, the unlisted company may be listed subject to compliance and exemption under Rule 19(2)(b). But if the intent is not to get listed, if the conditions could not be fulfilled, then what happens? There is no law. So that is what we are talking about.
Presently, it is not permitted.
Yes.
They need to comply with the SEBI delisting regulations, which we don't want to exempt, because this is a very elaborate mechanism which we have created. We don't want a bypass mechanism through which it can be circumvented. We want the companies to comply with the same.
Okay, sir, there are certain suggestions has come from the questions. One is they are saying the book value shall be highest of book value on the date of public announcement for counter offer, or book value on the date of intention of delist by the promoter, because they are saying in the recent one case, the book value was higher on the day of announcement, and after that company has done some transaction, so book value has reduced. So this is one suggestion has come. We will compile and send it to you, but I am just giving you, because paucity of time, we are not discussing this. Second is, they are saying RBB window currently is open for 5 working days, but it should be 10 working days, because there are sometimes the glitches are technical glitches are there, and some big companies are there, number of things are there. So somebody suggesting that 5 to 10 days should be there. Second is they are saying top 100, 200, 500, 1000 shareholder list are not made available, because now earlier Companies Act provided that you can get the list, but now you cannot get the list because companies are not providing this type of information. They are giving the ban post of 1 lakh shareholder or 2 lakh shareholder. So something should be worked out. If the investor is asking top 100 or 500 shareholder list, that can be provided. Second suggestion is, sir, provision for shareholders approval need to be looked into. Those who have sold the shares on a particular date, their vote not to be counted for. The point is that I sold the share, but I will get the voting right still there, and the person who got the who is getting share, he has no voting right. So the person who has no voting right, who has sold the share, he's not interested in anything, so he can give his comments without realizing, or he will not give comments. So this particular loophole should also be plugged into this. So that is another point which suggestion has come. The most important things are, there is some manipulative process has taken place in the past in the delisting. No doubt regulation 4 sub-regulation 5 is there, which restrict device, scheme, artifact, various things are there. But it has seen this, that buyback before delisting, this is one of the method. Preferential allotment to known person before delisting, though SEBI has restricted now for 6 months, they have given. Okay, so that has to be looked into this. Consolidation of face value to offer exit to small public shareholder. 10 rupees share has become 100 rupees. That has done by one company. So the small shareholder has been out. Cutting one of the deal with the large public shareholders. Okay, like you have transferred some share to the other shareholder. People can plan. You are checking only 6 months, but somebody has done before 1 year, and they have devised this particular thing. Cutting deals with investor of the company, which has seen in AstraZeneca's case also. Okay, they have given to somebody the 15% shares, and he has put in this. Then by funding to other parties to purchase shares of the company from the market. So these are some manipulative practices people have followed it. Okay, and then they have done this. So that should also be restricted. That should also be worked out. And one important point has come. Once person has given his delisting, like in a takeover, if I'm giving intention, then I have to take over the company, whatever it is. So same thing should happen for delisting also. So no doubt, only in one exception case, that RBB price is higher, then you can give exemption. For all other cases, if he has given intention, he has to take the shares of the public. He cannot do this, because sometimes the acquirer give the news in the market that he's taking over, but then he backed out, or he is not taking over. Once you are announcing that this company is going for delisting, share price is going up because people are expecting. So this loopholes also has to be plugged, sir. This is one aspect which we can see. Some international practices also there. We must see this, that these practices which are there in international market can be incorporated in SEBI delisting process, which are good one and which can helpful. We can compile it and give it to you, sir. Some international practices relating to delisting regulated class of security, because in India we are doing only equity delisting, but other part of the world, they are giving convertible instrument also. They are giving non-convertible instrument delisting is also allowed. So that is certain points which are there, which we can use. This is a time when you are doing something, some changes you are taking place, so we can do this. So all these suggestions, we will compile it and give it to you.
Thanks, Pavanji. I think a lot of suggestions have been received, and we appreciate all these suggestions. We will definitely look into the same.
So all the participants, those who have any other suggestion, because whatever suggestion you have given, I have asked, but some suggestions which are still there, you can send it to us. We can compile, or you can send it directly to SEBI also. You can do this. So I think we have come to the, we have already overshoot our time, because this was a very technical and interesting topic. So on behalf of all the participants and on behalf of corporate professionals, I thanks Achal Singh sir for your valuable contribution in giving the entire detail of each and every aspect, what is the background, why it has taken place, and it will definitely give clarity to everybody who is giving suggestion or who is just understanding that how the SEBI is doing. So I thank you very much. I thank Neeraj Modi also, and I thank Amarjit sir and Jeevan sir, who has readily accepted. And then this is a one of its kind program which I have told you. We have given the comments, but first time that regulator is interacting with public and giving its mind. So there is a very more clarity and more effective things will come to you. So thank you, Achal sir, for your valuable contribution. Thank you, Anjali. Thank you, Manoj. Thank you, Anuj, for giving. And my most important thanks to all participants, those who have patiently participating and sending their queries. Thank you very much. In the same direction, next Friday, some queries are there which are very important and creating a confusion in the corporate world. And Mr. Sundareshan sir, who is the executive director, will be participating. Narayan Shankar from Mahindra Mahindra, and Savitri Parekh from Reliance, and Mohini Vashne from Corporate Professional. They will give answer and they will work out the issues which our corporate world is facing and how it can be solved. So thank you all participants. I request all you to register for the next webinar on 11th, that is a Friday. And thank you very much for your participation in this program. Thank you very much, sir. Thank you.
Thank you, Pawan.
Thank you, sir.
Thank you, Anjali. Thank you,
Thank
Manoj.
you.
Thank you, Anuj. Thanks, everybody.
Thank you.
Thank you.
Thank you, sir.
Yeah, thank you, Neeraj. Thank you.
Thank you, sir.
And we will compile all the suggestion, Achal sir, and send it to you.
Yeah, definitely.
Yeah.